are sure that you have the answers and that you have, in some cases, documentation backing up what those answers are. The things I'm talking about are the ones that are bulleted here. The proper parties. So in that case, that would go both to individuals, making sure that you have their accurate names. You know, in my case, my name is Jeff Baxter. You would probably want to have Jeffrey G. Baxter or Jeffrey Garth Baxter. That's my middle name. I can hear the laughter already. If it's the name of an entity, you want to make sure that you have the proper entity name. That includes not only making sure, for instance, if you have someone that does business as, ABC Plumbing, but their actual entity is, XYZ Inc., you want to make sure that you have the entity itself, the XYZ Inc., as opposed to just the DBA name. That can also include the punctuation. There are different ways that you can abbreviate LLC. It could be LLC, no spaces, no periods. It can be L period, C period. It can be LC. It can be L period, C period. Making sure that your documentation includes the actual legal names of the entities is also important. That you have signatures for all the parties, that your notarization blocks are correct and fit within Iowa requirements. That you get the documents notarized. That's a key provision or a key element. You don't want to try to record a document that's not been notarized. Otherwise, the recorders are going to have an issue with you. Making sure that your legal descriptions, that your collateral descriptions in your financing statements accurately describe the property that you're intending to get. I can't tell you how many times I've seen incorrect legal descriptions or just the cut and paste from the assessor's website trying to be passed off as a legal description. That's not a legal description. That's not one that you want to use. You'll want to, find the actual legal description of the property to include in them, and that make sure that all of your documents agree. As you're going through your documents, you'll oftentimes have defined terms. The best practice would be making sure that those defined terms are consistent throughout all your documents, so that you're not referring to borrowers in one case or debtors in the other documents. Making sure that your documents are consistent is a good practice to make sure that you have consistency throughout your loan documents. At this point, we're going to go ahead and get into some specific provisions that you want to make sure that you have in your loan documents. We'll start with some of the big ones, the homestead provisions. Homestead protection is granted in Iowa code. It prevents you from being able to foreclose on certain property in certain instances. And so what you want to make sure that you have is the requisite language to waive those protections and allow you the ability to act on the property that you've got. Homestead applies to, this is under Iowa Code Section 561. It includes, it has to include a house. In order to get protection from the homestead, it must include a house that's used as a home by the owner itself. If you have more than one home, you can designate, an owner can designate which property is protected. The owner of the home can also include the beneficiaries of a trust. So it isn't just individuals. It can also be held in a family trust and still act as a homestead. The size limitations on homestead property is 40 acres or more of ag property. And if you're within a city plat, it's a half acre or less. And there's a recent case actually from, I think, January of 2017 that allowed for some tricky platting to allow or to provide homestead protection. In the particular case, there was an roughly acre parcel of land. The homestead protection obviously only applies to a half acre. So what this creative owner did is he had a homestead plat created and recorded that basically outlined the property in a 1-foot parcel or a 1-foot strip of land, and then included the driveway and the surrounding areas of the realist of the improvements on the property, and called that his homestead plat. So the non-protected, non-homestead plat included all of the side yards and the front yard and the rear yard of the property. And the bank objected to that, saying that it violated zoning requirements, and so it couldn't be protected as a homestead. And the court disagreed, saying that the only requirement that is in the statute is that basically the homeowner can provide a plat of any property they want, as long as it's used as the residence, used as a home by the owner. And so in this case, the owner was able to kind of put one over on the bank. So keep those kind of things in mind as you're working through your documents and making sure that you've got these protections in place. Otherwise, they can come back and bite you. You can have the homesteads are exempt from judicial sale, where there's no special declaration of statute to the contrary. In order to get the homestead protection, there has to be a waiver of that language, and that's specifically listed in statute. Here, the contract, or if you're, I'm sorry, let me back up. You can get an exemption of the homestead can be waived for ag land, specifically ag land, and that's anything greater than 40 acres. Anything less than 40 acres is what's in the previous section. But if it's greater than 40 acres, the waiver is going to be required to be boldface type, 10-point font or larger. It's got to be signed and dated by the person waiving the exemption at the time of the execution of that document. Usually in your documents, you'll see this is where you have that extra signature line immediately following the waiver, in addition to the final signature line for binding the party to the document. It must also require specific language that's set in statute. You likely, I would hope, have this in all of your documents, but it'll look pretty familiar to you. It is the language that you'll want to make sure that you have, and you want to make sure that you have it in there verbatim. And it states that you understood that the party signing understands that the homestead property is in many cases protected from the claims of creditors and exempt from judicial sale. And signing the contract, they voluntarily give up their right to this protection for the property with respect to the claims based upon this contract. If you don't have this language verbatim in your contract, make sure you get it in there. If you don't have it, you're going to run into problems with homestead issues. The next item on our list is going to be spouses. You have to have the signature of spouses in order in order for your protection. If the owners, well, realistically, one point that I try to tell clients is to make sure that you know the marital status of all of your borrowers. If you can get a representation from them as to that marital status, that'll help protect you if there is an issue down the line. There are exceptions. A few years ago, there were not exceptions, and several banks got burned by not getting a signature from a spouse. Now, the legislature has recognized that issue, and they put in some extra language into the statute that would accept, that would not provide the protection for the spouse. That basically the spouses are not going to get a house for free if they're. I think the termination by divorce has always been in there, and the encumbrance by a purchase money loan is new. But here, a court sitting in equity determines that invalidating the conveyance would unjustly enrich the non-signing spouse. That will probably protect you in most instances, but best practices, make sure that you have your spouses, or make sure that you have your borrowers correctly identified as being married or single, or I guess those are the only two things. But getting those, there's probably yeah, I don't know. Maybe we'll come up with something new here soon. But those are going to be your protections for spousal interests in the homestead. The next item that we're going to talk about is purchase money priority. Now, if you have a purchase money loan, you're going to get priority over pre-existing judgments of the purchasers. This is important in case you have a borrower that has some stuff that's outstanding, some outstanding judgment liens. This will protect you. You're going to need to have a reference in your document that the mortgage or that the loan is purchase money, the mortgage is purchase money, or protecting a purchase money loan. There isn't any specific statutory language to that effect. It can just simply say that it's a purchase money mortgage. It's not like the dragnet provision that Iowa law has regarding maximum credit available to the borrower, where you have specific language here. It doesn't have to have that kind of statutory language. It can be just a reference to that. But you're going to want to make sure that you have that in there. Otherwise, you're going to run into problems with priority over any judgments that the borrower may have, which you don't want. Next item is this is more for loans that deal with personal property. If you have collateral that includes personal property, you have to have a security agreement in order to attach that security interest. In order to perfect a security interest in loans, you have to have a security agreement. You have to have a proper description of the collateral, and then it has to be perfected in whatever form is required for the type of assets that you've got. But you have to have the security agreement. That's your first step in protecting yourself when you have collateral that is personal property. Now, the security agreement doesn't have to be a separate document. Oftentimes it is, because you want additional language spelling out your rights as the secured creditor, or there's a lot of reasons to have a separate security interest, but it's not essentially required in order to get yourself that protection. All it really simply has to say is that it's a security agreement, as defined in it just really has to say that it's a security agreement that protects your interest. This is some sample language that if you don't have a separate security agreement, you may want to contemplate including this language in your loan documents, because this should suffice in most instances. Really, all you're going to want to make sure that you do is adequately describe the property, and depending on what that property is, there's different ways that you can do that, but enough that will put other creditors on notice that you have the security interest in the property is kind of the essential element that you're looking for. The next few items that we're going to start looking into are loan terms that you may not have in your loan documents necessarily. If you use Laser Pro or Encompass or Walters Kluwe or any of the other loan document software suites, you may not have these specific provisions in your documents, and understanding that those software programs don't grant you great leeway in terms of adding additional language, you may want to think about having a standalone addendum that you can use in your documents, or if you can add these things to them, having them added to your base loan documents, just to make sure that you have protection from them. First thing that we're going to talk about is financial information and the right to inspect books. Oftentimes in your loans, the financial status of the borrower is going to be an important element to whether or not the bank agrees to make the loan or not. And obviously, people's financial situations can change over time. So you're going to want to have the right, or really the obligation for the borrower to provide them to you, but the right to review the financial statements of the borrower to determine their financial wherewithal, because if that materially changes, it may affect the borrower's ability to repay, which obviously is going to have a great impact on the bank's ability to collect. So in order to ensure that the bank has those rights, you want to build those rights into the loan documents. And if you can, the best practice is to have it as a requirement for the borrower to provide those to you quarterly or annually, or upon call from the bank, depending on how comfortable you are with your borrower and how likely you think it may be that they may have a changing financial position. This next slide is going to give you some sample language that you can include in your loan documents. It isn't magic language necessarily that you have to have, but it's there for your use. The next topic, or not the next topic, the next item is the right to inspect collateral. Similar to the financial status of the borrower, if you're getting collateral from, and I really what I'm thinking about here is mostly livestock or grain or anything like that. If you are getting what you think to be 1,000 cows, and time goes on, if you're not checking the collateral, if you don't have the right to check the collateral, you run into problems where potentially what you are relying on to secure your loan may be being lost to, either being sold or degradation of quality, or any other number of items. That if you don't have the right to inspect that collateral, and really this goes beyond just relying on the statements from your borrower, but the right to actually physically go on to the property of your borrower so that you can inspect, if you think you're getting 1,000 cow or 1,000 head of cattle, you want the ability to go out there and count them, make sure that there are still 1,000, or that that if you think that you're getting certain numbers in terms of quality, are they being fed? Are their living conditions good? These are all things that you want the ability to go out and see for yourselves to make sure that you're adequately protected. And again, this is some sample language that you can use, that you can include in your loan documents, that will give you those rights, because there isn't anything worse than thinking that you have collateral only to find out afterwards that either it's been sold off or it's degraded so badly to the point of being worthless. If it's grain, is the grain being stored correctly? Is it dry? Is there spoilage? What's the condition of it? These are all things that, as your loan progresses through its life, that if you're relying on that collateral to secure your loan, that it's there and that it's available to you. And so having the right to inspect that is going to be essential to you. The next item that's something you may want to consider putting into your agreement is the right to appoint a receiver. Now, what a receiver is going to do for you is they're going to be able to take over control of the operation and basically take control of all those assets that you're relying on as your collateral, and make sure that the borrower then can't sell the rest of them or allow them to degrade or get rid of them or retitle them. The receiver will have those powers to take over control. Now, there's going to be an added cost for that receiver, but depending on your particular situation, you may determine that cost is worth it. And again, here is some sample language for you that you can use to put into your loan documents to give you those rights. That's all the specific items that I have. As you go through and have new loans come through, these are provisions that you can put into your agreements and make sure that you're protected from a lending standpoint. If you don't have these in your existing loans, or you have entered into new loans recently that don't include these terms, but you want to make sure that you have them in there, one time that you can use to add them in there is at the time that you have a default from your lender and you start going through a workout or start going through a forbearance. That'll be a good opportunity for you to add these type of provisions into your loan documents, which is probably a good segue for Ben, who is going to be able to talk to you now about forbearance and about workout situation. So with that, I'll pass you on to Ben.
All right, good afternoon, guys. Again, I'm Ben Bruner, and I'll be talking about agricultural loan modifications, worked out considerations and alternatives to judicial foreclosure. And obviously, with the increased stress in the agricultural segment, hopefully this information will allow you to, I think, timely, properly, and efficiently respond in situations where you have non-performing yet still cooperative borrowers. So once you've truly identified a stressed agricultural credit,